Dr. Zavala holds a doctor law degree, and he is a visiting professor at Yale University and professor in Mexico. He has devoted his teaching and research career to human rights, focusing on the importance of citizenship for all. His topic today, penal reform in Mexico and human rights, is a very live issue. These two areas may appear sometimes as contradictions, but surely there is a connection. So the question to Dr. Zavala today, how can Mexico have a successful penal reform, and what would this success look like?
Well, thank you. First of all, thank you very much for inviting me. It's been a great honor, and I have to say thanks to the friendship with Professor Pierre, I would say that we have been working together and even in a good book about citizenship, security, and human rights in Mexico. And it's a real pleasure to be here again. And I would like to start my presentation about two of the main two reforms in Mexico. The one from 2008 about criminal law, the reform on criminal law, and the last one in 2011, the one on human rights. We cannot talk about human rights in Mexico without these two reforms. They are the cornerstone of the rule of law in Mexico, and I would say we are in the process of implementation. So I would like to start talking from the point of view about how important it's insert these two reforms in what we call public governance in Mexico, which means the process by which a society steers, rules, and manages itself, meaning essentially the process by which government, private corporations, civil society organizations, and citizens interact to define, agree, and decide on their goals of common value and on the organization form, kind of resources, and set of activities. On this public governance, we should include and insert these two main reforms in Mexico. On one hand, the governance process is not random or unrestricted, but structured and framed by institutions and by knowledge. It implies values. And the main and core value in Mexico now, in order to implement the rule of law, is precisely the idea of due process of law. Including due process of law means avoiding of different mistakes. The Mexican criminal proceedings have been probably part of or essential part of against the rule of law. So we're talking about why it's important to include into the process of governance these main reforms. And governance is the steering process by which the sense of direction of society from the rule of law and the social capacity to carry out public intentions are built and defined. So we would talk then about the process of implementation on rule of law through the process, due process of law in this new criminal law procedure and these new reforms in Mexico. So when we talk about values, institutions, rules, tradition, which establish the ways and limits of the exercise of public power, this process also provides the channels for participation in public authorities, private corporation, as I said, in addition, public governance, but as well to determine the efficient and allocation and management of public resources. Now Mexico is investing in the necessity of training police officers, training judges, training public officials, and training all the institutions about how to implement this new criminal law procedure reform in Mexico. It's quite important when we're speaking about governance in Mexico. The first idea that comes to our mind is about the significance of these two main reforms. The influence of leading role of the government now in Mexico is under change. And I would say that the most relevant and societal goals are now set up and achieved in these two main reforms, the one on criminal law procedure and the one on human rights. So I would like to stress on how important it's for Mexican governments include the process of new public governance, but on the other hand, governance is broader than government action, insofar as the steering process of society now covers joint initiatives between government and society. And I would say such as the people, the citizenship, increasing the knowledge and the importance of the rule of law. That's the only idea that's the main idea in which institutions in Mexico and the implementation of this criminal law reform is going to be implemented in such a good way. So that's the most important thing and the very first idea I would like to stress on this process. And of course, the second one is the one on human rights. Because human rights in Mexico, since these reforms in 2011, we arrived to a new, I would say, level of democracy and very powerful idea of the contents of human rights in democracy. For the first time, we include and insert in our charter the term of human rights. It used to be called individual guarantees or garantías individuales in the past, and now in Mexico we call already in the Article 1 of our Constitution the idea of human rights. The idea, the content, the meaning of the international human rights law. This is very important because after 6 years and since 2000, since the year 2000 when we started a new political process in Mexico after the transition, and now the accommodation of the government into the rule of democracy, they have decided to include and to accept and to even push the reforms on this idea of the importance of human rights or international human rights law in Mexico. We have court decisions from the regional system, the Inter-American Court of Human Rights. We have the debate of the decision from the Inter-American Court of Human Rights into the Mexican legislation, but as well, and what I consider is quite important is the meaning and the content of the term human rights in our constitutions. It's a cornerstone for the rule of law in Mexico. So what we're talking about, two main reforms as at the cornerstone of the due process of law, in which includes the respect, protect, and fulfill of human rights. This is the shift from government to governance, from government as usual, which means authority and the way in which they used to exercise the power and most of the time violating human rights, to the broader perspective of governance, has secured and is necessary indeed stress about this idea. The new government are finding the governance approach to be increasingly advantageous when dealing with complex, critical, and sensitive public policy issues in Mexico, as for example what happened with the French citizens Florence Cassés throughout the decision of the Supreme Court, because the due process of law was violated and it was a principle of human rights. The court decided just to release and to probably even, I would say, we shared in one way or another the idea of what is the core issue of this decision from the Supreme Court, the idea of implementing governance through human rights and the kind of democracy we're living now in Mexico. This shift from governance to governance means the shift to a real democracy. And it's the beginning of a more solid governance on the public or public governance in a very descriptive concept, portraying the collaborative methods of governments through the different institutions, particularly those in charge of implementing the law, and of course civil society, when the civil society, with this meaning of good governance, when governing through partnerships and networks with extra governmental actors, for example, the civil society, they are conceived as a model to government most applied to be political, legitimate, and effective. That's the main idea in which I would like to try the first point, a very important idea about why we are saying now Mexico's this shift from government to governance is based on the real idea of a democracy, of quality of democracy, because on one hand we have the reform of the criminal law, but on the other hand we have the reform on human rights. Now I would say in a very positive way, under I would say a liberal democracy assumption that we are into the effective government, into a political stability, into trying to get another public goals for civil society. We have enormous challenge in terms of economic, civil, and economic and social rights, for example. And when I think about the violation of economic, social, and cultural rights, means that in Mexico it's some sort of a schizophrenic idea about we have the richest men in the world, and we have 57 million people living in poverty. So we go into the idea of what does it mean exactly to violate human rights in terms of economic and social and cultural rights, but as well, what is the idea of the positive rights in terms of the state have to implement in such a good way the due process of law, institutional speaking, but as well in the very exact and precise approach from civil society, understanding the meaning and content of the due process of law. Sometimes there is a misunderstanding, and there is no real shift from governance from government to governance, because this lack of understanding between the two ideas from the civil society and from the government. But we are now in this process in which I would say this concept of good governance reached a more agreeable, though still controversial meaning in Mexico, but the real quality of democracy. The principles of characteristic of these two reforms are rule of law, legitimacy and voice participation from the people, from the civil society, transparency, accountability, responsiveness, effectiveness, and efficiency from institution, direction as well, strategic vision from the government, and I would say equity as well. Universal access to opportunities, included for minorities to maintain and improve their well-being in terms of accomplishing economic, social, cultural rights. That's the idea. But we are still at the beginning of a particular human rights, civil and political rights from a particular idea of what is the main content of the rule of law in Mexico, what is the main content about the international legal obligation from human rights perspective, what is the most important idea from democracy in Mexico of governance. I would say that's our main, the first step in order to get a quality of democracy in Mexico.
Gracias. Thank you very much, Dr. Zavala. Was very interesting. Now we have Dr. Daniel Dos Santos from the University of Ottawa. We have the privilege to have the great sociologist in his title today of his presentation, what are the elements that must be included within penal reforms in Latin America, or the elements of inclusion into penal reforms in Latin America? Certainly the question by itself implies that perhaps there is something that we had forgotten while using the law as a major policy instrument of development when major penal reforms were being made in Latin America. So I leave the floor to Dr. Dos Santos, and thank you very much for being with us today.
I wish to thank Pierre Gilles, I wish to thank the Human Rights Center, I wish to thank Gilles Bélanger and Ariel Sylvestre. It is really a pleasure, though on the eve of retirement, I still have a lot of things to say, I don't have enough time. So I had prepared a long discourse for today, but as I was listening to Dr. Zavala, I decided, well, forget it. So I'm going to try, okay, to be provocative, because I think reform of criminal justice and criminal law in Latin America, as elsewhere, is a big subject, is very important, and it has not been solved. It's been years and years of reforms, and we are still dealing more or less with the same justice system. Yeah. I just would like to cite one of the fathers of liberalism in England, Herbert Spencer, and one of the fathers of British sociology, in a small text that was translated in French with the title, The Right to Ignore the State. Somewhere he says something like this: as a corollary to the proposition that all institutions must be subordinated to the law of equal freedom, we cannot choose but admit the right of the citizens to adopt a condition of voluntary outlawry. Further away, he says, have we not seen the government is essentially immoral? It is not the offspring, no, is it not the offspring of evil, bearing about it all the marks of its parentage? Does it not exist because crime exists? Is it not strong, or, as we say, despotic, when crime is great? Is there not more liberty, that is, less government, as crime diminishes? And must not government cease when crime ceases, for very lack of objects on which to perform its function? Not only does magisterial power exist because of evil, but exists by evil. Violence is employed to maintain it, and all violence involves criminality. Soldiers, policemen, and jailers, swords, batons, and fetters are instruments for inflicting pain, and all infliction of pain is in the abstract wrong. The state employs evil weapons to subjugate evil, and is alike contaminated by the objects with which it deals, and the means by which it works. Morality cannot recognize it, for morality, being simply a statement of the perfect law, can give no countenance to anything growing out of and living by breaches of that law. Wherefore, legislative authority can never be ethical, must always be conventional merely. I think that Spencer was quite clear. Of course, his position was, some people don't talk about social Darwinism because that refers to sociology alone, but he was considered a sort of capitalist anarchist. In some ways, he thought that the state must be temporary, not something permanent. I just want to cite a couple of other things that seem quite important for me, and that I found in all papers that I read about the reform of criminal justice in Latin America. Even the World Bank is very worried about that. And of course, sociologists, anthropologists, lawyers, and so on, everybody writes about it. But most countries devote between 1 or 2% of their national budgets to their system. And almost all of that money is spent on salaries. The countries in which the justice system is less corrupt and more immune from the meddling of politicians are also ones where strong civilian institutions were long in place, for example, Costa Rica, and where ethical standards and the separation of powers were traditionally great. This thing about the separation of powers is a myth. From Montesquieu to Locke, by considering, in terms of the philosophy of liberalism, that there is a need, an essential need, and I think Montesquieu was aware of the danger, and when he proposed the separation of powers, it was really like creating checkups inside the state apparatus in order so that none of them could be dominant towards the other. Today, in most countries, the executive, which means the government, is at the top of the pyramid of the state. And lots of judges, prosecutors, courts are all created by government, and not by democracy. The debate and discussions about changing the way judges are appointed, increasing of justice budgets, the updating of technology, the reshuffling of the court structure, the formation and training of justice personnel, the decentralization of the judicial network have had little impact on the delivery of justice. And when I say justice here, I dare to say all of us look for a just justice. Public opinion in Latin America considers the judicial system on top of the list of the most corrupt, inefficient, and untrustworthy institutions. The false belief that the accusatorial process is more respectful of the due process rights, more effective in bringing the guilt to justice, less costly, more transparent, and more timely, shows that importing other systems or other items from different legal systems or cultures is not efficient in reforming the criminal justice system in Latin America. And one thing that I would like to mention is how much reform, and not only Latin America, almost across the world, the reform of the judicial system, the reform of criminal law, is ignorant about the history of the society in which it takes place. And that is quite important. And when I say that, I measure my words. What I mean is something like, if you're talking, for instance, what happened to Aboriginal people in Latin America? And by the way, across the world. Did these people constitute nations? Did these people produce norms, procedures, court systems, law? Did they? Of course they did. Where are they today? We ignore them. And when we reform, we always look to the state and to the legal profession, to the legislator, as we call it, to do the reform. If you talk even about constitutional law, we call for the constitutional experts to reform constitution. We don't talk to the people on which almost all the constitutions of the world say, we the people, like the Americans, okay? We the people. So it means, if you go back to the Greeks, that democracy has to be something in movement, in motion. And the reform, the law, has to be something in motion. If it doesn't include social change, then there is no reform. There is only cosmetic arrangements that only perpetuate the same legal culture, the same legal system. Another thing that I want to raise is the question that we are now, as most people like to say, I don't like it, but nevertheless I will say it, we live now in an age of globalization. It's quite incredible to see how states are struggling in order to come to grips to how do you coordinate, how do you create a coherent international legal system in which local law and international law can get together. On the basis of which principle? The basic one that we've been talking since French Revolution is the one that refers to the common good, l'intérêt général. Where is it? What is the intérêt général? In globalization, we can't, if we do reform, take the Palermo Convention about the trafficking of human beings. Okay? Most countries in the world have ratified that convention. So they are supposed now to apply it locally, their territories, to their population. And we know how this traffic is organized. We know the people who organize it. We know the people who commit from murders to money laundering and deposit money in our so-called very legal and very respectful banks. And yet, we have not been able, I would even say eradicate, to eliminate human beings trafficking, but at least to control it, to reduce it, and to control the damage that it is causing across the world. Where in the reform of criminal justice in Brazil, for instance, where is trafficking of human beings? This is a fundamental right of people. I mean, human rights, you talk about human rights, it's very important that human rights are not just something that is fixed in a law. Once you write a law and you're happy because now we have a chart of human rights, how do you implement it? How do you transform it into reality? The Charter of Human Rights says that there will be no sex discrimination, no racial discrimination. Everybody will have access to education, to health care. Where is it? You think that even in Canada, everybody has access to all those rights. So it's quite important that we look into the reform of criminal justice in Latin America, not only from the point of view of history, and history means that the world is not one, but is diversified. And this history shows that these different populations, I don't dare now call it nations, because as Benedict Anderson says, a nation and a state, they are imaginary and imagined. So those who have power, they imagine a territory in which they can have the control of the population and the land, the resources. And for that, the state needs to produce laws and need to more or less implement them. Why? Because I go back to Mr. Spencer. Okay? The state needs the crime to reproduce itself. If it stops criminalizing, there will be, well, I don't calculate in terms of the percentage, but I would say a vast sphere of the state will be in jeopardy. So it's quite important that we look at this history as a pluralistic history. And that means for me that the reform of criminal justice in Latin America has to take into account not only this diversity of populations, but also the diversity of the production and implementation of different forms of law. So law is not produced to the state. So probably we should look into more what the word in French is much better for me, to call it like the phénomène juridique, and not call it law. Because norms are more important than law. And today we are said by legal philosophers and lawyers and legal profession that state law is hegemonic. If it is hegemonic, dominant, then it means that Aboriginal law, customary law, I don't know, okay, all sorts of, I could say even informal laws are not important. It is mere social things. What is important for the state, it is its own law. But if the law doesn't translate into motion, then it gets fixed. If it's fixed, it doesn't change. And change is much needed in the field of justice. So in terms of culture, I would say that it is quite important also to refer to a long debate, which is the one that looks into legal pluralism. Without legal pluralism, we can make all sorts of state law reform, state justice reform. We won't change anything in the society. Because people, when they get together, when they are linked by different things like culture, and when I say culture, not only language, customs, mores, and things like that, they produce law and they regulate their lives not by state law, but by their own rule. So if I take the example in which I worked a lot of Africa, I could think that I did the experience in Angola by working with people from the former Kingdom of Congo. The Kingdom of Congo goes from Luanda, from the capital Angola, to the north to the two other Congos, Congo Brazzaville and Congo Kinshasa. And this is a very old kingdom. Of course, it doesn't exist in Angola. The Portuguese destroyed it. But the people in Congo, they still exist. And what you know, through oral tradition, they are going back very strongly to what are the rules, the norms and procedures that ruled once their kingdom. So the legal culture, though they destroyed the political structures of the kingdom, the legal culture of these people remains intact. And they are renewing it. And they are using it despite the state law. They don't give a damn to the state law. They are reforming their own. They are making marriages that have never been registered at the state. Okay. Seems a contradiction in terms, but nevertheless, it exists. So for a sociologist or an anthropologist, it's quite important that you look into this society and not only into this state. So that the reform must be something like Professor Zavala mentioned. For me, it's like the creation of a sort of a public space in terms that Habermas used to define it, the free use of reason and freedom to discuss in equal terms the policies. So criminal law reform must be a public policy, which I make a distinction from the state policy. And public policy means democratic governance. And democratic governance means that everybody is equal. Though they are different, all of us are equal. If we are really equal, then it means that if you want to make a reform of criminal law in Latin America, you have to bring together other people that are concerned by criminal law, including those the state calls criminal, to discuss about what they should do so that they can build a new justice. So I'm calling for, maybe because I'm a sociologist, I'm calling for a change of perspective in the way we take the reform of criminal justice. I would think that law and justice have to become real objects of study of all sorts of disciplines, academic disciplines, in terms of research. In that terms means that what all of us, and some of you at the law faculty and across the world, know very well when we talk about social legal studies, when you talk about law and society, when you talk about critical legal studies and things like that. It's because the link, we cannot separate and make law and just autonomous sphere of society. On the opposite, it is the link that exists between law and justice and the rest of the other spheres of society, like, for instance, economy. You cannot understand what's going on after the so-called financial crisis today in the world if you don't look the way we built these laws and we implemented them. So if you want to reform, it's not by the state picking up the money, giving it back to the banks and put the banks and the enterprises running again to make huge profits. Because, as Professor Zavala mentioned again, okay, though Mexico has advanced enormously, there's still plenty of people who have been left out. And so poverty, how can we still discuss today why poor people exist? Why, with so many policies from the state to eradicate poverty, today the rich get richer and the poor get poor? Where is the reform of justice if it doesn't take that into account? So there are different sorts of population. Branches, I don't know, some would call it some minorities, others would call it whatever, okay? When you talk about Aboriginal people, how come, if you look into history, that laws in this country, in any other country, like in Brazil, like in other countries of Latin America, have almost ignored the existence that they had slaves, they had a black population from African descent. And some of these countries, I remember the first time I went to Mexico. I went to a Congress, an Universal Congress of Sociology, the World Association. And there were also the Economists World Association that had a Congress. There are plenty of congresses in Mexico. The one on sociology were more than, I don't know, 5,000 people. And I recall talking to some Mexican friends in Mexico City, and I was asking, I don't see many black population. You guys don't have any blacks. You didn't use slavery. Oh no, now there's a couple of immigrants arriving and so on. And yet I discovered that they exist. Like in Peru, they used to say there is no such thing as blacks in Peru. And now I discover there are poets, singers, and things like that. They exist. So where is the law when we reform that we don't take into account these sorts of population that are at risk? And they are at risk because of our own misery, because of the way we built our own society and the way we implemented our justice system. So in some ways, I would like to say that the rule of law is very important. Human rights are very important. Yet, rule of law is just a concept. And the fact that all of us are equal before the law doesn't make the law apply to us all in an equal way, in an even way. On the opposite, law does exactly what exists as a social structure in society. It does reproduce that social structure because, as Philippe Robert and Claude Poseront did it for France, okay, when you look into the statistics of the state, because those are the only statistics that we have about criminals, okay, we are surprised to know that most of the people that are sent to jail come from the poor. And that most people that get fines are mostly rich people. Petty bourgeois and so on. And you know something? In France, courts give more fines than they send people to jail. Of course, jails are full. But then, if I look into the state statistic, I would say, come on, Pierre. The rich are more criminal than the poor. Why? Because I condone more often in criminal courts. But they don't go to jail, most of them. They pay fine. So these things have to be addressed by any reform of criminal justice. When I say rule of law, yes, it's very nice, the principle. How come that it's so hard when the state abuses power, when the state doesn't respect its own laws? It is so hard for us to bring the state before the courts. Sometimes we've been able to do it. Okay? Look, I give you, it's not Latin America, but I'm sorry, I'm talking about everybody, because I don't think Latin America has its own specificity. But, okay, the whole world needs a major justice reform, not only Latin America. Okay? And so we cannot refer to rule of law, to human rights, as if it was the West. Look at the pandas. You saw the pandas arriving in Canada? Oh, so beautiful. And now Mr. Harper doesn't talk anymore about human rights in China. It's not important. Business is business. Come on. So, you see, it's quite important for me that human rights don't be something that we fix in a law. We don't need a law of human rights. I don't know, maybe I'm too provocative, but I would say, I'm sorry, Zala.
Let's start with the debate.
Yeah, no, it's the sense so that I can have some people questioning. But I would say, the reason why I say that is because I think human rights should be in all of our heads. It should be in all of our social practice. We should practice all day, every day, night, everywhere in the world. And we should not wait only for the state to respect or to make respect the human rights. We need to live by human rights. We need to love our other. That's why I love you so much. Thank you.
Muito obrigado, Dr. Dos Santos. We have new people. It was very interesting, very kind of provocative, exactly. That's very good. I will take, since we have about 30 minutes, not more than that, we are opening our chat right away for some questions. I'm sorry if I don't read all the questions because it will be impossible. I will give, however, 2 minutes of reaction to Dr. Zavala to the comments, since we want to focus maybe on penal reform in Mexico today. So I'm giving you 2 minutes, not more than that, to react to, if you want, to Dr. Dos Santos' reflection. Maybe how can Mexico take advantage of those comments?
I'm very concerned about it because it's into the debate. First of all, I would like to just stress into the idea of this shift from government to governance, including not only the sociological idea of implementing human rights, but as well the implementation of international human rights law into the constitutionalism all over the world. I mean, we're going to talk about the implementation in every country of a public policy on human rights, which should include in 3 main components. One on governance, that I already talked about it, and something is quite important, and what happened exactly in Mexico is about a constitutionalist element within international law, and third, the duty progressively to realize the due process of law as an immediate process in which the citizen is going to be assert the idea of the government implementing the rule of law, but as well to realize economic and social rights to the maximum available resources, to which social rights are granted as well. So I'm including the whole idea of human rights, civil and political rights, economic, social, and cultural rights. So we cannot, we must not deny the idea of constitutionalism into the national laws in all other different constitutions all over the world. We can actually now be certain about the idea of almost 80% of the constitutions all over the world. Now they all included the term human rights. Mexico is probably one of the last change of this process, but we already did. So we are obliged, we are on the law enforcement of the what we call the international human rights law regime, but as well the international human rights system. So this is very important not only for the compliance of sociological human rights idea, but as well the reason for compliance with law using the international law, but as well the national law system. That is essentially what in Mexico we just arrived on the very clear idea of the next step in our democracy, the defending the rule of law as a core issue into the constitutionalism, and the very clear idea about how this process, the process of law, is now including every institution in Mexico, particularly those in charge of implementing the rule of law.
Muchísimas gracias. We're going to open the floor. We have a question already, and we're going to go to Marie Sylvestre as a question. At the same time, there's another question, Canada involvement with Mexico criminal justice reform. What Canada could do better, the strengths, weaknesses. So this is one question, and we'll go with another question right away. Marie-Ève? If it's too different, we'll do one and one.
Excuse me, would you please repeat the question? I couldn't hear because
okay, the question, Louis, what Canada could do better in the, it's probably like, I'll summarize it, something like in the international aid to Mexico on the criminal justice reform, what Canada could do better.
Okay, well, what it's been actually already done in terms of the way in which the government of Canada has been committed with Mexico in implementing policies on how to respect, protect, and fulfill human rights in Mexico. So it's been actually applauded, it's been recognized by the international community, many times leading not only by the money invested in Mexico through the Canadian organizations, but as well through the training. I mean, Canada has been involved in training police officers in Mexico. Canada has been involved in training judges in Mexico as well. Canada has been involved in many different Mexican states, trying to get the better quality of democracy. So this is important because that means the international leading role that has been playing by the Canadian government is only recognized by the idea how important is human rights in Mexico. But on the other hand, I think it's something very important, it's including the idea of, and a very clear idea about immigration reforms and the concept of these immigration reforms in the interaction between Mexican government and Canadian government. This is a very important issue because I have been probably involved in some sort of research, and I think it's very important the idea of what is the idea of the Canadian government around legal or illegal immigration and the perspective of human rights. And what is the idea in Mexico? What Mexico is doing linked with Canada in doing something for immigrants in Mexico as well. So the very clear idea for the different awards and different sentences from the Canadian Supreme Court about immigration implementing this idea, very idea about immigration reforms in Mexico as well. So this is very important issue we have to raise in the meaning of the immigration reform in Mexico as well, because we defend, protect, and we do everything to protect our immigrants, illegal immigrants in the United States. But Mexico is failing a lot in protect immigrants, illegal immigrants coming from the south and the path from Mexico to the United States. We have a very bad record in defending and protecting the right to life from these immigrants coming from Mexico. We should do something regarding, and we will include a Canadian government and academic world in this process.
I have a question for Danielle. I want to ask you to develop a little bit on something that you said that I found interesting. I found many things interesting, but there's one thing that I was hoping you could develop on. Lots of these law reform projects emphasize the importance of reforming procedure. In particular, you mentioned in your presentation that there's an assumption in those law reforms that a shift to a accusatorial regime will be more responsive to human rights and due process. So in your opinion, from what I take from your presentation, and I was hoping that you could develop on this, it's not a question of procedure or a question of which regime we adopt. It's a question of changing our understanding of rights and of the state as well, and of norms. Is that what I get from it? Like, can you comment on the importance or lack of importance of reforming procedure and changing regimes?
Yeah, a couple of weeks ago, I had a very nice interview with one of our justices from the Supreme Court. He said, Mexico is living a very important process ongoing about argumenting or implementing human rights in the different level of the government. I mean, the idea, the content, the procedure of human rights leading now from the government perspective to every level of the institution and government in Mexico. So this is the starting point. I mean, changing the understanding of rights means training judges, developing as well the concept of human rights in this three level of government, but as well implementing the idea of governance into the Mexican government. This is very important because I've been training police officers in the municipality in Mexico, and what I've found it's a lack of a clear understanding about human rights from the very beginning, and that happens at the very local level. So can you imagine the idea of having these problems in the federal government? There's no what we call transversal, I mean core issue in the different areas of the government. Now Mexican government developing a national development plan. From that national development plan is going to include as well the Human Rights Action Plan 2008 till 2013, 2008, and the end of the term of the presidential government. So the idea that the next challenge is about changing the understanding of rights from the constitution reforms into the public policy concerning the committed of the three levels of government, I mean federal, state, and local, into human rights public policy. That's the next challenge of Mexican government from Mexican government. That's the main challenge in the idea of how are we going to train not only the judicial, but as well the executive and as well the legislative areas on the state and local governments. When we arrive at that point, we're going to put this understanding about the clear idea of human rights in Mexico.
Dr. Dos Santos, what do you think?
I won't be referring to the same thing that Zavala has talked about, but referring to the question of Marie-Ève, I would say, though I was provocative, okay, I have not excluded that the state is among one of the producers of norms, rules, and procedures. Okay? So in that sense, what I'm trying to distinguish is the fact that there is not only what the state produces, there's also what the society produces. So in those terms, if states, common law tradition or civil law tradition, and I'm referring only to the Western countries, okay, have chose to use accusatorial or inquisitorial, others say adversarial, non-adversarial, and so on. It doesn't matter the name. What I'm interested as a sociologist, is to see the results of that procedure. And of course, there is nothing that proves to me that one is more costly than the other, the one is more efficient than the other, and so on and so on. In the end, they produce the same thing. They produce the criminal. And they produce the statistics that the state needs to reproduce the crime and the criminal. So in that sense, of course, I'm not for one or for the other. It doesn't matter. Okay? We can choose, we can discuss from the state perspective which one is less costly, more timely, that allows to arrest more criminals and things like that. But that's from the state perspective. From the society perspective, what is important is to find another way to distinguish itself from what the state does. So in those terms, procedures are open to discussion. It's a question of public space. If you use public space in the term that, of course, not everybody agrees with Habermas, okay? But if you use public space as a space in which we can use with freedom and reason, we can be free and we can discuss openly, we can oppose, we can criticize openly, then we have a debate. And that's the essential debate of what democracy is about. So it's all a movement. So the procedure today may be accusatorial, tomorrow it may be inquisitorial, it doesn't matter, or something that is a mix of all that. But states, they won't change it. But nevertheless, you see, United States have been starting to use some of what the civil law uses to. And civil laws are at 82% common law. And with globalization, you have now enterprises, firms, corporations, producing law that doesn't go through the state. And they solve their problems among themselves. It's only when they can't escape to the state law that they have this battalion of lawyers that go to the courts for them and try to influence law, try to solve the problem with the state. Mostly, now there is a parallel world, and it's a very disorderly world, like French professor of law. No. She writes a lot on globalization and law. Marty. As she reminds us all the time, this is a false debate. The main debate for developing a procedure, criminal law, criminal justice, if you're only referring to state law, state justice, okay. But even that is open to discussion. Doesn't mean that the state wants to change it, okay? But you are open to discussion, to question. You have to make studies to see, is it really more efficient? Is it really more democratic? How much?
Let me back to the idea, Professor, as you said, in the case of cassettes in Mexico, foreign cassettes in Mexico. It's a very good and clear example. A lady who's accused as a kidnapper in kidnapping in Mexico. It's a very clear idea because French government was putting pressure into the Mexican government because the very clear idea, the French, coming from the French Revolution about the content of due process of law and the concept of including the value of presumed innocence. From constitutional reforms in Mexico, the very clear idea of what happened with foreign cassettes is because the Supreme Court decided to arrive to the habeas corpus because of the very clear idea about in a democracy we should respect the due process of law, which is included in the national French Constitution since 70s. I mean, 17th century. I mean, from the 18th century. So that's a very clear idea about how this different point of view from Mexico idea of recent idea of how important the process of law with the international human rights law standards, and what is important from the national and from the Constitution, from the idea and the French Revolution in the 18th century of the idea of the process of law and presumed innocence as well.
I just want to, it's not an answer to what you said, it's just debating democratically, okay? If you think that you can do criminal justice without the interference of politics, process, you would be able not to get this interference from politicians and so on?
Yeah, well, at the end, actually, it was a very, unfortunately, for the civil society in Mexico, because there is a lack of education about and cultural lacking of experience about the due process law in Mexico. Because, for example, 89% of the Mexican citizens concluded that the Supreme Court failed in the process of releasing Florence Cassés from jail. So, at the end of the day, it was because of lack of education of the real content about the process of law, about democratic process in Mexico, and in terms of implementing international human rights law. So, unfortunately, this is a lack of education and the process of being a real democracy in Mexico. When the citizens arrive, the idea of how important is the process of law in a democracy, how important is the international human rights law standards, how important is now we accepted international human rights law standards in our constitution, international law treaties. And because of that, the Supreme Court decided to include the habeas corpus into our own law, and through the amparo, which is as well another reform in Mexico, very important. Now, because of the amparo, Florence Cassés was released from jail, and she flew into French and supported by the French government, not because of politics, because of democratic ideas. I don't think, although all the diplomatic work that's been done by the French government, it was a very important variable at the end of the day, but certainly it's because we need to learn how to implement international legal standards and due process law.
I have just a couple of examples. The United States of America were quite eager to take on the French bourgeois that, how do you say, accaparó? Acaparar. Well, they took the wealth of Jews during the war and so on, the Second World War, and they accumulated wealth from these people. And the Americans were eager to put the French fire of the French government and so on, so that they could force them to repay back to the families of these Jews. Yet, the same courts in the United States have refused until now to put for trial Dow Chemical for the Bhopal massacre. More than 3,000, and there is still some people dying today because of that. You see? So politics get into it, and when the relations are between two states, different states, yes, and procedures too. So it doesn't matter if it was one accusatorial or the other one inquisitorial, the result was the same. They discriminate against. And there is one little thing that I know there is one Brazilian here, okay, you won't contradict me. Brazil has a very, no, here. Brazil is a very modern Republican democratic constitution now, okay? And yet, you know, if you and me, we rob a bank in Brazil, if they catch us, you know, we are entitled to a special imprisonment. You know what that means? Yeah. It's written in the law. It goes against the Constitution, And how come that even today, no judge, no lawyer, no prosecutor, no, I don't know, social movement, political movement, goes to the courts of the Brazilian federal state and says, you're doing an unconstitutional thing. You're abusing. This is discrimination and it's against human rights. It's against civil rights.
Yes.
So,
yes, I do agree.
Of course, in Canada or in the United States, we don't have that thing. Huh? Our Constitution is above all. But of course, some of us sometimes are lucky to get special imprisonment. It's a procedure is not so important.
Dr. Lamache, you had a question, I think.
Yeah, I do. Thank you very much for your presentation and presence, Dr. Zavala. I have a very modest question, actually. Would I belong to a Mexican NGO, and would I be concerned about the reform that you described a few minutes ago? What should I expect about measurement or output or impact? In other words, as a member of civil society, what is my expectation about the point of measuring who benefits or who benefited from the procedural criminal reform? What are the tools, and are they
from what? Would you please
structured with civil society?
I'm so sorry, because I couldn't hear you. Would you please?
Yeah, it's about measurement.
Okay. A measurement about implementation of human rights in Mexico, measurement about judicial procedures.
I'm talking about the criminal procedure reform and the measurement of it, and the communication of results to civil society. Okay. Thank you.
Okay. I think this is a very important question, because we're talking about procedurally fair government. May also help to encourage human rights in Mexico through the citizenship and the idea of legitimacy. Now, at least what I've heard, and I've been working in Mexico City, is the idea of developing indicators and measuring about the right to trial, the right to criminal proceeding in terms of respecting the process of law. So by adhering to procedural justice in its decision-making process and its treatment of citizens, the Mexican government, through the indicators, the idea of how important is citizens should treat one another in terms of accountability and rule of law. So this is very important. Over time, one common attitude and action used to be an unthinkable at the past, but now we trying to develop a common identity and produce expectation about a fair treatment, regardless ethnic, racial, religious, and any sort of unfair treatment before the law. So we are now doing indicators, and we are now measuring at the Mexico City government, I mean at a local government, and then we need to increase the idea of developing and measuring through indicators the idea of criminal proceedings and criminal reforms and criminal justice, as well in a local and in a state and local level. It's something that we need to go to the next step.
There was a question right here.
Mi pregunta es provocada por el profesor Dos Santos y quiero conocer cómo ha sido implementada la Convención 169 de la Organización Internacional del Trabajo, tanto pues en el sistema judicial mexicano y en la reforma penal.
Okay, we have very important reform because of the criminal reform in Mexico now includes from this convention of an international legal organization coming from system. Now it is included in some.
Can you repeat, please? We lost you for a second. Can you repeat, please?
Yeah. What I was doing is now the ILO Convention 169 now has been applied through a special procedure for indigenous people in the criminal justice system. So that's a very important procedure in terms of law in Mexico, but I think at this stage we're talking about the lack of information and training of local judges to implement this convention of the International Labor Organization. We have already the law, but we are not still implementing through the criminal procedures this law. That's our problem in Mexico, particularly because of different levels of knowledge and training and judges in that part of Mexico, with the idea of indigenous people. I would say that in the way in which we are going to promote and implement criminal and justice criminal reforms through the indigenous justice idea among the different levels of the government is going to be a very important procedure in order to implement the due process law in Mexico for indigenous people.
You had a question? No, I have a question for both of you actually, who touches that if there's no, is that there's that Mexican movie, as everybody knows, probably Presumed Guilty.
Yeah.
And the doctorate students who's doing the investigations are giving an answer to one of the interviewer of, I think it was CNN, why those judges didn't listen, didn't see the people that are in jail, because in Mexico it's a big issue. There's a lot of people, not only in Mexico, a lot of Latin American countries, they put a lot of people in jail. Yeah. And the answer of that researcher, and we'd like to hear Dr. Dos Santos before Dr. Zavala on that, the answer of the student was, those judges don't think that they are human beings. And that was his answer. So, and I think it goes into the heart of the problem. And it goes along with the question of procedure. Yes, procedure, yes, reform. But what about if they're not considered, and if it's 85% of the criminals or those who are doing some action as considered criminals are not considered human beings? So he was honest.
I cannot refer specifically to Mexico, but I will give you a straightforward example. A long time ago, at the Universidad Federal Fluminense in Niterói, I was invited to participate in a seminar with not only anthropologists, but military police, civil police, judges, prosecutors, lawyers, discuss about, is a child a human being? And
we lost Dr. Zavala to get in back.
Did I continue?
Yeah, because we're going to discuss one. We'll listen to your answer.
And the question was, is a child a human being? Because if the child is a human being, then a child has rights. And of course, anthropologists and sociologists, we are all, right, of course the child is a human being, of course the child has rights. And starting by you guys, the police, you should start by respecting them. You should talk to them, you should read their rights and protect them, and so on and so on and so on. But then when it came to the turn of judges and prosecutors, we all had the same opinion as policemen. No, a child is not a human being. A child has no rights. He's not an adult. So they would treat the children as they treated. For instance, the massacre of Candelaria in Rio de Janeiro, where, I don't know, 20 children were massacred by the police. You. Why? Because they are nobody. And as these children, there are many other children and many other adults across Latin America, and as a matter of fact, across the world, that states and the upper classes look down as they are Nobody. So they don't have rights. And this is the problem, because Dr. Zavala was talking about how eager he is to defend the citizenship. So for me, it's quite different, because I started to learn about citizenship in my classes about the period of law and state. And it was always like, of course, law is the state law. And the state supplies the legitimate violence and legitimate force so that law becomes enforced. In that sense, when I learned that, it became clear to me that there were people who had rights, who did not have rights. Those who had rights were called by the state as citizens. Why? Because they were submitted to the state. They accept what Etienne de la Boétie used to call l'obéissance, the obedience, involuntary obedience. Okay? But it is not. It is not, because a citizen does not belong to the state. It is not the state that gives us the citizenship. State wants us as nationals. They say, you are a Canadian. I give you a passport, an identity card, but in turn, you have to submit to me. And then I call you a Canadian citizen. This is crazy. A citizen is a member of society. I'm a citizen because I know you and I link to you. So what we call in French lien social, the social linkage, is quite important in order to understand that we have to forge, we have to build our own rights. And then we have to impose them on the state, on the institutions and so on across society, so that they respect it. Because if they want us to fulfill our obligations towards society, they want to recognize that all of us have rights. So it's quite important for me. So I wouldn't be surprised, because it's not the first time in Latin America or Brazil, as a matter of fact, not only in Mexico, that they look to a certain social classes or social group like they are nobody. In Africa, you look to a peasant. These stupid guys from town, the urban people, they look to the peasants like they are nobody. They look to the people who live in the shanty towns. They look at, it's nobody. The favelas, who are these guys? You can kill them, it's easy. And that's what the police does in Brazil. Not only killing the so-called bandidos and so on, no, it's killing also the people of the favela. Okay. So, I'm sorry.
Is there a last question? I know that Dr. Zavala is able to hear us, but I'm not sure he will be able to answer in time. But meanwhile, we have time for one last question. So to end this, you have kind of, if you hear us, the last word, Dr. Zavala. The question was, if some or too many people are not citizens or human beings, how can a penal reform be success? And how can we do it?
Let me back action in terms of, I would say, and I want to stress the idea of implementing public policy on criminal proceedings and as a core issue of the process of law. This sort of public policy in human rights is still far from the definition of a policy success. I mean, a policy, even in criminal proceedings, it's successful if it achieves the goals that proponents set out to achieve and attracts no criticism of any significance of support, which is universally through international human rights law. Yet not everyone perceives government's achievements in terms of due process of law. For instance, the politics of torture in Mexico because of the insecurity and unfortunately, torture it's a public policy carried out by Mexican government and is still on the process of the Supreme Court saying we are now under the obligation of we have signed all international treaty. Now it's in our constitution the idea of forbidding torture in Mexico. There's a lot of NGOs working and avoiding torture in the tree level of government, but there's not successful policy throughout the institution in Mexico in criminal law proceeding. That's just an example of what is happening now in order to implement the policy cycle of avoiding torture in Mexico, for example. If we go to the idea of avoiding torture, we need to implement public policy involving the citizens committed in the idea of there's no way other than hand out any person, criminal, or under the category of a criminal, we cannot torture because of that we're going to receive the information even from the idea or the debate around the tipping time, the time ticking bomb. I mean, even that idea that is in the international human rights debate, in Mexico it's still important to, from the civil society, to accept the idea, for example, torturing is not the way in which we're going to implement a policy cycle avoiding torture through criminal proceedings. That's the same example that you said, Pierre, about the presumption of guilty trial in Mexico.
Muy bien, muchísimas gracias. Estamos a tiempo. We got it into an hour and a half. It's a lot of material of information. We'll put on our website some of your material that you kind of promised to write sooner or later. You told me. So that will be very useful, fruitful, and it's a little step forward, and we will continue. So I really appreciate your comment. I really appreciate the everybody of you and those who are participating in the webinar, and those who are not there but will be there in the future through the virtual system. Thank you very much. Muito obrigado. Merci beaucoup. Adios.
Thank you very much, everyone. Thank you.